Hi, my name's Anna and I want to take us through vicarious liability as a summary to help you understand the tort topic. So what you may find useful is to get some paper and pens and go through it with me as I write it on the board. So, vicarious liability. You have to excuse my handwriting, it's even worse on smart boards. But I just wanted to go through to try and outline the handout that you're going to be working on here. Vicarious liability isn't a tort as such. Instead, it's a rule that applies to other torts. Vicarious liability means you are liable for the actions of somebody else. So you might have heard of living vicariously before. It means living through someone else's experiences. So vicarious liability is where you are liable for the torts of another. Now, that's really important because it goes against the whole idea of tort law, where you are at fault, you are at blame, so you have to pay. Vicarious liability is where an employer isn't at fault, but they still have to pay. They are still held responsible for what their employees do. There is a number of reasons why the law has this mechanism. So, for example, it acts as a deterrent. It sends a very strong message to employers that they need to train their staff properly. So if they don't uphold high standards of behaviour and conduct, employers will be responsible for employees' actions. So, for example, in the case of Tesco versus Brent, the staff members sold underage people videos that they were too young for. If Tesco wasn't held responsible for that, they may not uphold such high standards for their employees. It also makes more sense because the employer has more money than the individual employee will. So we call the individual employee a man of straw. In other words, they're not really made of much. So there's no point in suing them because the claimant isn't going to get much compensation off them. Whereas the employer has what we call deeper pockets. What that means is they've probably got more money, they can recoup that money from lost profits, and also they're probably insured as well in case people get injured. Other reasons that we have this, that we justify this, is that we can increase our costs to get the money back if we need to. So businesses are in a strong position. They're also in control of what their employees do. So they should be stopping their employees from committing torts or doing things that are wrong. So once you understand the reasoning behind vicarious liability, you have to then understand the mechanisms, how it works. So what we have, first off, is the innocent claimant. Now, this person has been negatively affected by something that someone else has done. So a tort has been committed. And that tort was committed by the employee, which, for ease sake, I'm going to refer to as EE. Now, this person is the one that's actually committed the tort. And we have a phrase for this, we have a word for this. A tortfeasor, a person who does the tort. Now, normally we would sue the tortfeasor. So, for example, if you were in a car accident, you would generally sue the driver. They're going to be the tortfeasor, and that's very, very straightforward. But remember, in cases of vicarious liability, we aren't suing the tortfeasor. We're suing the employer, or the ER. This person is actually the defendant. So although this is the person that has done the wrong, the tort, in most cases we're going to sue the employer. Now, you've actually studied a number of cases already of vicarious liability. So anytime we've sued a business or a hospital or a council, that's vicarious liability. So, for example, in Montgomery versus Lanarkshire Health Board, we didn't sue the individual doctor, we're suing the hospital. You might remember, for example, the case of Bradford versus Robinson Rentals. We're not suing the individual employer that told them go, we're suing the company. So the employer has to take responsibility for their actions. Now, there are a couple of mechanisms just to be aware of. So one thing is that you can actually sue both of these people jointly instead. So you can ask for half of the money off their employee and half of the money off the employer. It's called joint liability. There's not much point in doing that because you're only going to get the same amount of money anyway. The other thing just to be aware of is that actually, if the employer is sued, the employee can be sued back. So the employer pays the claimant and then the employer sues to recover that money back. In reality, this is rare because in reality, the employee doesn't have the money to pay back. That's usually why they've got deeper pockets. What they're more likely to do is discipline or fire that employee. So this is how it works. So now we need to know the rules. When is it that we can sue someone else for the actions of the employee? When can we sue the employer? There's 3 steps that have to be established. So, step 1. We need to establish that the tortfeasor was an employee of the defendant. Well, that's obvious. You can't sue someone if they're not responsible for that person, but actually it's not always straightforward. So for example, Uber drivers are a really good example of this. There's been lots of cases recently with companies like Uber, Deliveroo, where they have disputed whether they are employees or whether they're actually self-employed. Now, if you're self-employed, there is no employer to sue. So that's the first thing that we have to establish. Now, there's no easy straight answer here. And the courts have developed a number of different tests that will help them decide if the tortfeasor is an employee of the defendant. Because if you ask the defendant, is this person your employee? They're going to try and wriggle out of it so they're not liable for their actions. So unfortunately, there isn't one single easy test to establish step 1. You have to apply a number of them. And I'm going to go through those. So the first test that we go through is the oldest, and I think one of the simplest. We call it the control test. Now, quite simply, the more control D has over how T, the tortfeasor, works, the more likely they're an employee. Think of a job, for example, working at Starbucks. The organisation will probably lay out exactly how the employee does their job, what to wear, what to say, how to prepare all the food and drinks. The employee doesn't have much autonomy. The employer is very much in control. This test doesn't work too well though, where the expertise is the other way around. So for example, a surgeon is the person with all the expertise, but in reality they're probably still considered an employee of a hospital. So the control test on its own doesn't help in every situation. So the next test you might want to talk about is the integration test. So, is their role, and that's really important, that's their role, integral to business purposes, or are they just accessory? Now, it's important to understand this is not about the individual. Most individuals in a business can be replaced. So, for example, if a college wants to offer A-level law, they will have to employ law teachers. Now, if I or one of your law teachers was to leave, they would just recruit another. As an individual, I am not integral to the organisation, but my job as law teacher is, if we want to provide A-level law. If you're not integral, you're just accessory. You make the business better, but you're not needed for the business to do its core purposes. So for example, a cleaner will make the college better because it will make it a nicer, cleaner place to work. But we could provide A-levels without cleaners, it would just be more disgusting. So they are accessory to a college and therefore less likely to be an employee. However, if you think of a cleaning business, cleaners are going to be pretty integral to that job, to that business purpose. So cleaners are probably likely to be employed by a cleaning company. So that's another test that we can use to help us answer this question. Are they actually your employee? Now, another test is the economic reality test. And this is where the courts will look at the financial factors. So, for example, they will look at things like, how are you paid? Are you paid per job? Or are you paid hourly, monthly? Who provides insurance? Who pays the tax? Who sorts out that? Who calculates tax? Are you provided with a uniform? Do you have to provide your own equipment, like a van, tools, or is it all provided for you? So for example, if you go back to that Starbucks worker, they are probably an employee if you look at their economic reality. So for example, they'll be provided with a uniform, they'll be paid hourly, Starbucks will work out their pay for them and sort out the tax for them, and they are of course provided with the materials that they need to work with. If you think of someone perhaps like a painter decorator, they may have their own van, they may have to buy all their own equipment, they aren't paid hourly, they're paid per job they do, and therefore they have to sort out their own sick pay, etc. They're more likely to be self-employed. Another key factor is whether they can turn down work. So for example, I think hospitality workers at St James's Park, they can turn work down if they want to. You don't have to work an event. That suggests that they're more likely to be self-employed. These are the three main tests, but the courts have started asking another question just to be aware of. There is another situation that they have started recognising. So it might not just be this, it might be a relationship akin to employment. Now, akin means similar. So for example, we've seen this happen a lot in cases of the church. It's hard to say that, like for example, priests are really employees. We also saw it in the case of Cox versus the Ministry of Justice, where we were looking at a prisoner who was doing work during their prison sentence. It's hard to say that the prison is an employer of the prisoner who was working. But the courts have said, well, if their relationship is similar to employment, they can be classed as vicariously liable. So for example, the prison was paying their prisoners to work in the kitchens. There were some similarities to a kind of normal job there. So although there's a lot of tests, we still don't necessarily have a clear answer. And unfortunately for you, it's just a case of going through, applying each one, and then it's a bit of, what is it directing you to? You know, best of three, what are the tests telling you? Now, stage 2, you'll be glad to know, is really quite short. Now, it's the longest one in an actual court case, but it's the shortest thing you would have to talk about in an answer. did T commit a tort? So, for example, the claimant would have to prove that they committed a tort, such as negligence or nuisance. They were injured and there's occupier's liability. They would have a claim in Rylands. This is going to be the long one to prove in court, but in an exam question, you would just have to say that T committed a potential, whatever you think it is. So if a delivery driver crashes their car, that because they're texting while driving, the tortfeasor committed a potential negligence. You don't then have to go through all of the different rules of negligence in a vicarious liability question. So we could move swiftly on. Stage 3. This is the toughest one to do. So what I'm going to do is I'm going to pause here so you can review your notes up to now, and then I'll continue with step 3, how we actually decide if the employee has done an action the employer should be held responsible for.